Okay, so I want to start with Ed. Your reaction.
There was a lot there. I think that the high point for the House manager's case is when Rusty Hardin rehabilitated Mr. Vassar and got him to explain that, they actually more or less did have evidence, when they went to the FBI, and clarify that, look, when I said we didn't have evidence, I just meant that we didn't turn over documents to the FBI. And that's great rehabilitation, but the underlying issue with that is that you have a very senior lawyer with the Attorney General's office who's saying that he doesn't know according to Rusty, the legal definition of what evidence is in a criminal case. That kind of goes to, that witness's credibility and his expertise, and whether or not these really were, experts advising the Attorney General appropriately, and whether or not their opinion should have been followed.
Sorry.
So it's great rehabilitation, but it also emphasizes a point for the defense that, Mr. Vassar really, is not a very experienced lawyer whose opinion the Attorney General should have deferred to.
Right. And then, Rusty Hardin does rehabilitate this whole letterhead gate situation, right?
Yes, he does let Vassar explain that the office had several letterheads that were used for different purposes. And then, in fact, Ken Paxton himself has signed a letter on a piece of paper that had a letterhead without Ken Paxton's name on it. The Attorney General himself has used those. So they were not altering government documents, which is a crime, and that they were using standard use of different letterheads for different purposes, as many corporations and businesses do, as do many state agencies. It's a non-issue that the defense has been blowing up smoke about.
Does that hurt the defense that this is kind of proven to be kind of what we thought it was, which is that people use different letterheads?
To me, I think the defense has scored a lot of points with this one issue, because I agree with that there are multiple letterheads. You can use one letterhead for one purpose and use another letterhead for another purpose. That seems pretty straightforward. But the witness's inability to explain how this particular letterhead was used, and that there was a decision made and there's a reason for it, which is probably mainly that, look, we wanted to use this letterhead because it seemed the most appropriate one, and it was the one that's, more readily available to us, or it's the one that we wanted to use because we were acting as a group and not really with the Attorney General, at his direction, and so we didn't think having his name on this letterhead was appropriate given what we were doing with this document. I'm also still not sure what this document is that the defense keeps pointing to that had the wrong letterhead according to the defense. I'd like to see what that document is and why it's so important.
Yeah, it seems like it was such an easy explanation why they just couldn't say, we decided we would use the letterhead without his name on it.
Right, and why that wasn't just out there from the beginning.
I think this is going to be the letter, and see, I'm not positive, but I wonder if it's the one, I think it may be the letter they send to Kamek that kind of makes him orders him to cease and desist. I think that's what it is. I think that's what we're talking about.
That would make sense.
It makes a lot, because I think that's what it is, because they send him, I'm going on my recollection from Bangert's testimony that's what we're talking about. We're talking about this letter that when they get word that that Kamek has delivered all these subpoenas to these banks that are, and to the, trying to get these email records and phone records for, law enforcement and various things, that they send him this, letter telling him, hey, you're no longer, knock it off, you're done.
Yeah.
And so I believe that is what we're talking about.
But I will tell you, the defense has made a great deal of hay out of their inability to just say that plainly and simply. And it is kind of surprising, because Bangert did a good job, generally, of giving those kind of explanations.
Yep.
And doing it without getting flustered. And it's interesting that on this particular...
It's such an easy explanation.
It is.
It's just so...
And maybe to them it was such a nothing that they hadn't even thought about an answer. But it's been 3 days now. You ought to be able to come up with an answer.
And on the point of Bangert, I think he was clearly the strongest witness for the House manager's side. And I have to give credit to Mr. Little because he's shown to be a very nimble defense lawyer. And what I mean by that is that yesterday, I think he came out of the gate very strong. Rusty wasn't objecting, and so he kind of took liberties with, I think with bullying, to some extent, Mr. Vassar and getting him to make statements like, we had no evidence when we went to the FBI. So Mr. Little was able to kind of use that tactic to get statements he wanted that are helpful sound bites to the defense side. But then today, I think what you see is him kind of toning it back a little bit and being very lawyerly and methodical and going through the evidence one by one, because yesterday he was challenging Mr. Vassar to give him statements that he didn't know he was going to get. Like, no one could predict that Mr. Vassar would say he didn't have any evidence when we went to go see the FBI. Today, Mr. Little knows the documents. He knows what they say. So he's taking a different approach. He's using a different tone and pace and kind of going through the documents one by one. And I think he did a very good job, in that respect.
How?
And one last point though about Mr. Bangert. It's very interesting to me, like along those lines of Mr. Little, just being a very crafty lawyer. He used Mr. Vassar to impeach Mr. Bangert. So at some point when Mr. Bangert was testifying, they realized, look, we got these text messages that he participated in. We've got some zingers here about what he's saying. They purposely chose not to use those text messages and cross-examine Mr. Bangert with them, to have Mr. Bangert give an explanation, which we all would expect him to do, that seemed reasonable. And they used those documents instead in cross-examining Mr. Vassar to use Mr. Vassar to impeach Mr. Bangert. That's very skillful, and I think you're starting to see how the defense lawyers are really, being very smart as to how they're pursuing their case.
And in that instance, Hardin was silent while they were asking Vassar to explain what Brian Bogert meant. And he could have objected to that. He couldn't say he knew what Ryan Bogert meant. I mean,
remind folks what that exchange was that he was trying to impeach him on.
Impeach Mr. Vassar with Mr. Bangert's testimony.
Well, Mr. Bangert,
or statements in the text messages.
Yeah.
I think generally during that time, Mr. Little was trying to get Mr. Vassar to admit that they were discussing, news articles, that they were preparing their own press release and their own statement that would be issued to the press, that they were anticipating the press covering the matter.
Media frenzy.
And so they had a statement from Mr. Bangert that related to those topics. And I think, basically Mr. Little kind of succeeded in bringing Mr. Bangert together with Mr. Vassar and the other folks Mr. Vassar was talking to through text messages, bringing them all together as one group that kind of were, either being silly in their communications with one another, being immature, themselves being, kind of vindictive, or strategizing, as to how they would present themselves in the press.
As not serious people.
Succeeded in bringing Mr. Bangert into this theme that these are not serious lawyers.
Yeah.
Well, and it was really sloppy on the part of Vassar and Bangert and Maxwell and Brickman to be texting like this. It's just sloppy.
It is sloppy, but so
it's sloppy,
human.
but very human. I mean, I'm sure we've all done it. But when you're going to the FBI and you're going to make an allegation of this nature against the Attorney General of the state of Texas,
Yeah.
pick up the phone.
Yeah, I think hindsight's always 20/20, but when you're a white-collar lawyer representing an individual in their situation, first thing you tell them is, I'm your lawyer. I'm advising you not to have communications, by email, text, in writing in any form, social media that could be used against you in cross-examination. That's the first thing a lawyer would advise someone like these folks to do. Unclear whether or not that was ever advised to them. Also, these are very experienced lawyers, so I can see a lawyer representing them maybe feeling like he or she didn't need to tell them because they should know. Yeah. But I think we're seeing the results of that mistake kind of play out right now in this trial.
Yeah, I mean, again, I think there's a somewhat innocent explanation for the text. Again, it's the kind of almost like locker room talk that people engage in, but when you have to get on the stand and explain what you meant or you didn't meant, and when he asked, are you insulting your colleagues? Well, you were. Just say, yeah, we thought they were, they were too inexperienced to take these jobs, and so yeah, it was insulting.
I think a big problem here is assumed knowledge. Their attorneys assumed that these attorneys surely knew this, so they knew to behave, and well, may have known it, but they didn't think it applied to them.
Well, that's generally why lawyers are advised not to represent themselves.
Exactly.
And so, you think people would do certain things, but not necessarily. Ed, are there any other points where you think that the defense really landed?
I think the defense did a very good job just kind of keeping Mr. Vassar on his heels. So at one point they asked him, well, look, how many outside counsel does the Attorney General's office hire each year? And then Mr. Vassar gave an answer that made it seem like, oh, we hire a lot of outside counsel. But I understood from the testimony this week that they hire very few outside counsel to handle criminal matters. And so Mr. Vassar didn't really address that distinction. And also defense counsel said, well, look, how many lawyers, are at the Attorney General's office and that dealt with Nate Paul matters? And then, Mr. Vassar had to say, well, look, there were relatively few, maybe there were 15.
Right, but they were all high ranking.
But had he said, look, but of the high ranking senior staff within the office, the percentage of us that actually dealt with Nate Paul matters is actually very high. So those were examples where, Mr. Vassar didn't clarify points.
It wasn't
that he
the whole
have.
800 lawyers that was affected. It was the top staff.
And so that leads me to believe that, really there was not as much prep as you would normally expect to see. I mean, a prepped witness, I think, would be anticipating that kind of line of cross-examination and would be able to, address it appropriately to, support his testimony, that he believed that what the Attorney General was doing was wrong.
Okay, folks. Any other thoughts before we take a break for lunch? And I'm hoping those lunches arrived because I got to go down and check.
Well, I think that that there's a poll out today, the Texas Politics Project at the University of Texas at Austin, that shows that 47% of registered voters in Texas, all registered voters, say that Paxton should be removed. And 18% says he's not done anything wrong. 35% don't have an option. That's everybody. But what the piece of this that I found interesting was the Republicans. 24% said he should be removed, which is a little higher than I would have said. 43% said they don't know. And a third said he should not be removed. Now that 43% who said they don't know is a huge block of the unknown for those Republican senators sitting in that room trying to calibrate their own political future. And what are they going to hear from their voters when they go home this weekend?
Because ultimately this is political.
It is political. And I just think they aren't getting any help here from these. This is not giving them any guidance. This poll also showed that as late as August 2023, polls showed that only a third of voters had heard anything about Paxton's legal problems, including the impeachment.
Well,
only a third of voters had heard anything about them. So when you say, oh, these informed Texans reelected him, not so informed, apparently.
Well, I had a very good friend, and I won't say who it is because it's a mutual friend, who, when I said I was covering the Ken Paxton impeachment trial, this person was like, well, who's Ken Paxton? And I was like, oh my gosh.
There you go.
Wow.
I mean, not only does Texas have a problem with a low voter turnout, we have a huge problem with low voter information.
Yeah, and
Yeah.
that, and so it's if you know who Ken Paxton is, are you paying attention? And most people are not going to take the time to watch a live stream and watch all the testimony. And although we have had quite a few people watching, but nowhere near like millions of people or anything like that. So, but anyway, well, we're going to take a break, and I'm going to go figure out where Ed and Katie's lunch is. And we'll. Oh, there it is. It just arrived, just as if on cue. So we're going to take a break so we can all eat, and we will come back. Since they actually took a 1 hour break, we'll try to come back about 10 till. We'll be back.